So welcome everybody to this webinar today, where we'll be speaking about the cosmetic beauty industry and the challenges posed by a lack of regulation. My name is Sarah Rose and I'm a Principal Associate in our Medical Malpractice team. And today I'm joined by Felicity, Hale, Principal Associate, and Hannah Hale, a Chartered Legal Executive, both from our casualty team. Just a few bits of housekeeping before we kick off. This session is being recorded, and whilst you can see us, we cannot see you. We hope to have time for a Q&A session at the end of today. And if you have any questions, please post them in the Q&A box at the bottom of your screen. And my colleague and Senior Legal Advisor, Harriet Strevens, will pick them up for us at the end. Where we run out of time, we will of course deal with any questions separately after the session by email. And of course, please feel free to contact us directly after today with any questions you may have. So on to today's agenda. We're going to look at the cosmetic beauty industry. We're going to start by looking at the current regulations, the current area, and then move on to some issues of regulation and consent, and finally finish with some case studies where we'll hopefully wrap up the issues that we've talked about throughout the course of the session. So without further ado, I'll hand over to Felicity to kick us off.
Thanks, Sarah. Today I'm looking at the 21st century use of social media, self-publication and self-promotion, the role of influencers, our obsession with perceived beauty and maintaining an online persona, and the easy access to social media content. The landscape of the beauty industry has changed dramatically over the last 2 decades, with the emergence of social media platforms providing a launch pad for new products and new treatments. This has seen the industry become more fluid, with fashions changing rapidly and extremes becoming normalised. The impact of social media has been felt most strongly in cosmetic surgery and non-surgical treatments, where the emergence of influencers has seen everyday people taking a much keener interest in their appearance. Maintaining an attractive online and striking online profile has become big business. There is more and more pressure, particularly on younger generation, to look better than their very best. And as a result, the cosmetic industry within the UK continues to grow at an exponential rate, with the filler market alone valued at £1 billion a year. The surge has seen younger generations undertaking more cosmetic surgery or non-surgical treatments than ever before, as shown in this slide. And these figures are ever increasing. But all this activity brings with it danger. Inevitably, younger consumers are drawn to less experienced surgeons or beauticians, simply because they are more affordable. Generally speaking, the younger end of the market has less disposable income, and they find themselves using cheaper providers. Sadly, this has seen an increase in botched treatments. Safe Face is a national government-approved register of accredited non-surgical treatment practitioners, and the organisation has seen a significant increase of 328% in complaints. So what is being done about it? Well, at last, the concerns surrounding these botched treatments have finally resulted in legislation which now outlaws certain procedures for under 18s. From October last year, a new law in England banned under 18s from receiving Botox and fillers in a move that signals a tightening of the regulation within the cosmetic industry. The Botulinum Toxin and Cosmetic Fillers Children Act now makes it an offence for persons or businesses to administer or to arrange to administer Botox or fillers for a cosmetic purpose to under 18s. The new law aims to protect young people from harm, and practitioners must be satisfied that their patients are over 18. It is a defence to show that they took reasonable steps to establish the customer's age and that they reasonably believed the client was over 18. But the legislation is certainly a step in the right direction. The Act does not create a blanket ban on Botox or fillers for under 18s, and procedures can still be carried out if you are duly registered. But the penalties for breaching the Act include criminal prosecution and an unlimited fine. The all-party parliamentary group known as APPG prepared a report into beauty aesthetics and wellbeing, which made 17 recommendations. The group concluded that the lack of legal framework around training and standards in the industry not only left consumers at risk, but also undermined competent providers. Therefore, this Act is a further step on the regulatory journey of the UK cosmetic industry. To complement this new law, adverts for cosmetic surgery that target under 18s are to be banned from 25th May this year onwards. This has recently been announced by the UK advertising watchdog. The new rules for the Committee of Advertising Practice, CAP, cover both surgical and non-surgical interventions, and they include the procedures set out in this slide. From May onwards, companies will no longer be able to advertise these procedures in a way that target under 18s, and many different types of adverts are covered by these new rules, as you'll see from this slide. Essentially, advertising aimed directly at under 18s, or where the age group forms more than 25% of the overall audience, will be banned. But I should point out that the ban will not affect adverts for cosmetics such as creams, makeup, and hair products. You might remember that in 2018, adverts for breast surgery shown during the reality show Love Island were banned for being irresponsible and harmful. This is exactly the type of advertising that will be targeted by these new rules. This move follows a public consultation that was carried out in September 2020. The consultation was responding to concerns about the potential harm of advertising these cosmetic interventions to children and young people. And those concerns were about body image pressures and mental health problems, as well as the suitability, risks, and potential complications of those procedures. So what's in the pipeline? A recent BBC News article reported on plans to ban unlicensed Botox providers in England. The Health and Social Care Secretary, Sajid David, says he's committed to making it an offence for someone to operate without a licence. It is acknowledged the complications can include infections, lumps, bruising, and even blindness. An amendment to the Health and Care Bill was tabled at the beginning of this month, and I'm pleased to say that it was successful. Now the government could have the power to introduce a licensing regime for Botox and fillers. So in conclusion, the new Act, CAP's new advertising rules, and the proposed amendment to the Health and Care Bill are all moves towards a much more responsible position. Historically, and even now, this area of the industry has been seen as the Wild West, with young, impressionable girls and boys targeted to change their appearance just for the sake of becoming better clickbait, strengthening their online following, or to simply make themselves feel better. Some of these treatments can cause serious physical and mental health damage. If not carried out properly, a patient can be left with devastating consequences, and in the worst cases, they might require continuing care or therapy. It is a reason why, from both the patient's and insurers' perspectives, practitioners' credentials should be researched and thoroughly scrutinised before relationships begin. I shall now pass you on to my colleague Sarah, who will address the regulation in this area, or the lack of, and the question of client consent.
Thanks, Felicity. In 2013, the Department of Health said that a person having non-surgical cosmetic intervention has no more protection and redress than someone buying a ballpoint pen or a toothbrush. It's a fairly stark comment, I'm sure you'll agree, and hopefully, as Felicity has mentioned, we are on the right path for improvement. But the reality is that presently the regulation is simply not as strict as arguably it should be. A large number of these procedures overlap the cosmetic beauty and the surgical spheres, but to suggest that the only difference is price is far from true. As Felicity has mentioned, there are a number of accredited self-regulators who seek to impose guidelines for members of the cosmetic beauty industry to follow. However, registration is voluntary, not required by law, and often limits practitioners to certain types of treatment, which prevents the desire to join. Guidance states that individuals should hold indemnity and liability insurance appropriate for their role, but there's no legal requirement to hold that indemnity. So how does this differ from medical professionals? As you can see on the screen, the GMC offer guidance to those doctors offering cosmetic interventions. And they state that they'll set, in some cases, a higher standard than in other guidance to address the specific safety issues and ethical concerns particular to the cosmetic sector. And to maintain their license to practice, doctors must demonstrate through the revalidation process that they work in line with the principles and values set out in their guidance. A number of the competency standards that doctors are held to are now shown on the slide. And you'll see that in respect to the issue of consent, this includes having a clear discussion with the patient about the outcome, benefits, and risks, and giving the patient time to consider the impact of their decision. In addition, guidance is published by the Royal College of Surgeons and the British Association of Aesthetic Plastic Surgeons, and there is a legal obligation to carry adequate and appropriate insurance or indemnity for the practice being undertaken in the UK. So why does this difference matter? To the consumer, the more regulated the field, the more protection they're likely to get. But the same is also true for the practitioner. The more regulated their field, the more up to date on legal developments they'll be, and the less likely they are to fall foul of expectations. One of the biggest issues we face when defending clinical negligence claims of this nature is the issue of informed consent. The principle of requiring consent should hopefully be well known to all in these fields. Without it, the individual providing the treatment runs the risk of being exposed to the civil and criminal offence of battery, professional negligence claims, complaints, and regulatory issues. But the law on consent is constantly evolving. It's not set in statute, it develops through case law, and it's no longer enough to show that you've followed the same practice your colleagues do. Actions have to be capable of withstanding logical analysis, and on the consent front, it must be informed. And that means taking into account the risks that are considered material to the individual patient in front of you. It's simply not a one-size-fits-all approach. So how do we defend the claims? It's important to remember that for many of these patients, this is their only experience of the procedure. For the clinician, it may well be the 10th identical procedure they've followed that day. Now, there's no doubting that some patients will be particularly memorable, but the issue becomes that can, 4 years down the line, the clinician remember the exact words they used to that memorable patient in a consultation 4 years ago? The likelihood is not. Although the patient's memory will also be affected, the courts are tending to find that the patient's memory is likely to be the more reliable. Evidencing the discussion is key, but a contemporaneous note, which is almost certainly not verbatim, will not necessarily provide a complete defence. And you'll see on the screen the quotes from the recent decision of Toombs and Mitchell. And in that matter, the court found that whilst the GP had a note, it was inadequate. And that meant that his evidence was not as reliable as it would have been if the note had been as complete as it should have been. Some common issues that we see with consent forms are found on the screen now. A properly worded and detailed consent form will certainly assist, particularly where it's provided to the patient in advance of the procedure with sufficient time to read it. But the fact that issues can occur in such a highly regulated sector as the medical sphere simply brings to the fore the problems that can arise where you have a non-regulated industry with often vulnerable individuals seeking treatment, the consequences of which they do not fully understand. And the concern we have is that without increased regulation and awareness of the need for detailed notes of discussions, practitioners operating in this industry risk being exposed to large claims with little defence. I'll now pass over to Hannah, who will illustrate with some recent case examples the difficulties facing practitioners in the sector and how they can address them.
Thanks, Sarah. So we're going to have a look at when cosmetic procedures go wrong. So over the last few years, we've seen an increase in claims for damages where procedures have gone wrong. There are a range of cosmetic procedures on offer, both invasive and non-invasive, which would be deemed to fall short of surgical procedure. These include hair dyeing treatments, lip fillers, Botox injections, waxing, and laser hair removal. I'm going to talk about two cases involving intense pulsed light, or IPL, laser hair removal treatment, which has gone wrong, and how consent played a vital role in determining the outcome of those cases. So, what is IPL? IPL is defined by the NHS as a cosmetic procedure that uses a powerful laser or intense pulsed light to remove unwanted hair. The NHS lists a number of possible side effects which can result from this treatment, which are listed on the slide. The laser is applied to the skin to target the hair follicle, which in turn causes it to fall out and prevent further growth. The procedure is not a pleasant procedure and is described as feeling like having an elastic band being continuously flicked against your skin. It is not unusual for some discomfort to be felt during this procedure. As with all cosmetic procedures, a person should be made aware of the potential side effects and asked to give their informed consent to confirm that they are happy to proceed despite those risks involved. So the first case study that I'm going to look at involved a young woman who attended the defendant's salon for IPL hair removal. The treatment was to be completed over a course of 5 appointments. Consent had been given and the claimant did not have an adverse reaction when patch tested. The claimant had 3 subsequent treatments without issue. On the 4th treatment, she suffered an adverse reaction under her right armpit. The consent form signed by the claimant had listed the potential side effects as highlighted on the slide. Just as a side note, in this circumstance, it's quite difficult to envisage a scenario where anyone going to receive such treatment, despite the risks listed, would perhaps not consent to the treatment taking place, particularly against a desire to look better or to fit in, which perhaps is overshadowing them actually looking at the consent form in detail. But back to this particular case, the claimant reported some irritation and provided photographs after her 4th treatment. The photographs showed redness and blistering under her right armpit. There was no indication within treatment records that the laser had been applied negligently or on an incorrect setting. In fact, the same settings had been applied on all previous visits. Her contemporaneous GP records and the claimant's expert medical evidence supported that the claimant had suffered a superficial burn which had not gone beyond the top layer of her skin. Importantly, the claimant was left with some mild scarring. Liability was disputed in this case from the outset, and proceedings were ultimately issued by the claimant. The case was defended to trial on the basis that the claimant had been made aware of the risks and she had given her consent to treatment. She had conceded in her own witness evidence that she fully understood the risks of the procedure. There was a good paper trail showing that the laser had been applied correctly, and there was no suggestion that the laser itself was defective. Finally, the injury, being a light burn and blister, had fell within the ambit of the consent given. The case was actually decided upon that final factor as whether the injury she had suffered did indeed fall within what the claimant had consented to. The judge on this occasion did not accept that it did. Whilst accepting that consent had been given to the risk of light burns, blistering and redness, there was no mention within the consent form of scarring, and the judge found that this then fell outside what the claimant had consented to. My own view on this is that that's a strict application, as it would not be unreasonable to think, no matter how light a burn or a wound or a laceration may be, that a person may have some residual scarring. However, the downfall in this case was the fact that the consent form did not mention that word specifically, and the claimant was able to safely say that she was not aware of the risk. The case highlights in an ever-growing industry the importance of consent and perhaps a person being made categorically aware of what they are actually consenting to. The approach taken by the judge in this case is not too different than the standards described by Sarah earlier as what perhaps would be applied when somebody has a surgical procedure. My next case study also goes on to look at that very point. So what is the precise risk? Again, this was a case involving a young woman who attended the defendant's salon, again for IPL treatment, this time to her abdomen and bikini line. The risks identified on the defendant's consent form are again listed on the slide. The claimant was patch tested and suffered an adverse reaction, confirming her unsuitability. for the treatment. Liability was disputed on the basis that the patch test was performed for the very purpose of determining if somebody can proceed with the full treatment. The patch test had been correctly performed and the laser was again applied on the correct settings for the claimant's skin tone. There was actually a dispute in this case as to whether consent had actually been obtained in the first place. However, assuming that consent was taken, the claimant had agreed to those risks as highlighted on the slide. The claimant went on to suffer some hyperpigmentation to her abdomen and was left with an L-shaped marking across her stomach. This was described by the medical expert as a superficial burn resulting in 2 types of permanent pigmentary change. Part 35 questions were raised of the claimant's expert to comment upon this residual hyperpigmentation and whether he agreed that this fell within the consent given. The expert accepted the consent form did list blistering and pigmentary changes. However, he appropriately commented that the consent that had been given was that such changes would last for only a period of 3 to 6 months. He had already provided opinion that the changes suffered by the claimant would be permanent. This is another example of where the wording of the consent form arguably falls short, and in this case resulted in the claim being settled. So in conclusion, these 2 cases highlight that as the popularity of cosmetic procedures grow, it is important for beauticians and practitioners to ensure that consent quite literally covers all known risks of the procedure.
Thanks, Hannah. Hopefully through that session, we've highlighted some of the risks that arise for practitioners in this area and the changes that could be implemented through increased regulation. I'm now going to pass over to Harriet for the Q&A.
Thank you very much, Sarah. We have got a couple of questions we've got time for, and if I might direct the first one to Felicity, please. The question is, how can insurers check that their insured practitioners can illustrate that they've complied with or are complying with the new legislation? And by that, I'm talking about the botulinum toxin and cosmetic fillers act and the health and care bill.
I think practitioners have really got to be diligent, and they've got to be making sure that they take steps to verify every patient's age, if that be by pre-treatment questionnaires, either online or on paper, then those should be undertaken, and checks for to verify age should be made. All those inquiries need to be recorded, and those records should be retained for a minimum, in my view, of 3 years. Essentially, practitioners need to be keeping a thorough paper trail.
Thank you very much indeed. How about you, Sarah? Do you have any views as to how practitioners can tighten up their consent orders?
I think with consent forms, obviously the ideal consent form would be a verbatim note, but we all know that in reality that's unlikely to be possible. So they need to be as thorough as possible. You need to be mindful of the fact that you need to think about the material risks for that patient, not just the general risks. Practitioners need to be aware of what they're providing. So if these are consent forms that have been produced by the manufacturer of the product, for example, they need to know what those say, they need to be familiar with the terms, and they need to be taking the patients through them. And I think it's just a step away from the fact that this isn't just somebody walking in to get a procedure which will then be done with. These can have devastating consequences, and for both the client, but also for the practitioner. And so the more of a paper trail, as Felicity said, really, the more you've got documented, the better your position will be. But really being familiar with the risks of what you're doing and making sure you've got a full record.
Have you come across circumstances where there's a blueprint being used for certain specialties, or does that not really exist anywhere to your knowledge? A blueprint consent form, that is.
I think there are sort of common consent forms, and I don't think there's necessarily something wrong with that, but you can't just rely on the fact that that will have everything in it, and you need to be making sure that you've covered off anything additional that you're aware of or that's additional for this particular patient or a particular discussion.
So really that's the template, fine, but don't follow it slavishly. It's dependent upon that particular patient you're dealing with.
Yeah, I think so.
Yeah. Just a last time question, if we've got time for, to direct at Hannah, please. What do you think about the outcome of the case study, the first judgment in the case study?
I thought it was a very harsh decision where the wording on the consent form had been taken quite literally, or the lack of wording in this case being it had omitted the word scar. I think, as I said earlier, it's perhaps not unreasonable to think that you could suffer a scar if you've had a burn, no matter how superficial. But I think that, whilst I think it was an unfair decision, judge took the view that that's a word that should have been on there, and a word that the claimant, or a sort of a consequence of the treatment that the claimant hadn't actually consented to, which was to go on and suffer a permanent scar. So my own view is that it was a harsh decision, but I understood the decision.
Thank you very much indeed. Very fascinating topic, all of the discussions we've had this morning, but unfortunately we're running out of time. So I shall finish my session and pass back to you, Sarah, to close up, if I may.
Right, so thank you everybody for joining us. We do hope that you found today useful. I think there may be a couple of extra questions that we've not got to, and we'll make sure we come back to you directly. And as I said at the start, if you do have any questions to follow up after this, please do get in touch with us, and we'll make sure we come back to you. Thanks very much and have a great rest of your day.